Managing a company in China can be a complex task, with one of the most challenging aspects being how to handle layoffs. How does one navigate this process correctly and legally? To begin, let's delve into the concept of economic layoffs, a situation where a company due to economic difficulties wishes to reduce the number of its employees. This is a legally permissible action based on Article 41 of the Labour Contract Law, which allows companies facing severe operational difficulties to reduce their workforce. Economic layoffs can be characterized by three particular traits. Firstly, it involves collective layoffs of more than 20 people or over 10% of the total workforce. Secondly, it applies to situations including company bankruptcy, severe operational difficulties, shifts in production, technological innovation, operational changes, and other significant changes in objective circumstances that make the fulfillment of labour contracts impossible. Lastly, the procedure must involve informing and obtaining opinions from the labour union or employee representatives and reporting to the competent department. The law not only sets numerical requirements for lawful economic layoffs, but also requires the fulfillment of substantive and procedural conditions. There are three circumstances under which economic layoffs can occur. The first circumstance involves companies undergoing restructuring in accordance with bankruptcy laws. If a company is unable to settle its debts, has liabilities exceeding assets, or is evidently lacking solvency, it can apply for restructuring through the court. Once the court approves the restructuring, the company meets the substantive conditions for economic layoffs. The second circumstance involves companies facing severe operational difficulties. In the past, the Labour Department and some localities, such as Tianjin, have outlined rules for determining severe operational difficulties, based on factors such as 2 to 3 years of operational losses, rate of work stoppage, and proportion of employees on standby. However, as these standards are too stringent for companies, courts often review company financial reports and other documents from the past 2 to 3 years to determine if losses have occurred. The third circumstance pertains to companies undergoing technological transformation that necessitates staff reduction. This includes shifts in production, major technological innovation, operational changes, and other significant changes in economic conditions that make the fulfillment of labour contracts impossible. Economic layoffs must also follow a legal procedure. Companies must inform and hear opinions from the labour union or employee representatives and report to the Labour Administration Department. Violating these procedures will constitute illegal dismissal. In conclusion, handling layoffs in China is a delicate process that requires a deep understanding of the law and a careful approach to ensure the legal rights of all parties involved are upheld. As a company, be aware of the conditions under which economic layoffs can occur and the legal procedures that need to be followed. Remember, failure to adhere to these rules can result in illegal dismissal and potential legal repercussions. Take note, certain types of employees are legally protected from dismissal during economic layoffs. In the world of business, knowledge is power. Understanding the ins and outs of economic layoffs in China is a crucial step for any business owner navigating the complexities of running a company. Should you have further questions, don't hesitate to reach out to Dong Wang at wwd@royallaw.com. As the founding partner of Royal Law Firm in China and a barrister and solicitor in New Zealand, he's an expert in the field and can provide valuable insight and advice.